Hello friends, Contract Act 1872 is our topic of discussion. This topic is part of IPCC Paper 2, Business Law, Ethics and Communication. In the first part of our discussion on Contract Act, we shall have a brief introduction of this Act. What we shall discuss here is some introductory ideas about contract and the Contract Act, and shall also get meaning of some basic terms associated with contract like contract, agreement, promise, consideration. Let's start with developing a basic idea about the need and purpose of the Contract Act. Friends, we enter into contracts so many times in a day that in fact a contract has become an indispensable part of our life. We may have lots and lots of examples of contracts being executed on a daily basis. People purchasing newspaper in the morning, going to movie in the evening, catching a bus in afternoon. These all are examples of contracts at a smaller level. And then a company purchasing a whole business, this is also a contract at a larger level. The basic ingredient of all these contracts are same, which we will be discussing in next slides. In fact, any business is in a sense a series of contracts made on a regular basis. In a business, nothing is done except a contract is being made on a particular time and then on a regular basis. Now as per law, a person is free to contract on any terms he chooses. What shall be the terms and conditions of a particular contract? What shall be the rights and duties of the parties? These all are decided by the parties themselves. The law does not intervene so as to decide terms and conditions. This is done by the parties. The law only says that if a contract complies with all the requirements of law, it shall be binding on all the parties to the contract. Then no party can go back from a properly made contract even if the terms of contract comes out to be favorable to that party. Every party is bound by a validly made contract. The Contract Act 1872 basically consists of limitations, restrictions, subject to which a legal contract may be executed and entered. It doesn't prescribe what should be the terms and conditions of a contract, but it prescribes the limitations within which a valid contract may be entered, it may be executed. The law gives us ingredients of a legally enforceable valid contract. What will make a contract a legally enforceable contract? This is what is prescribed by Act, and then this Act further deals with certain special types of contracts like indemnity, guarantee, bailment, pledge, etc. In all our remaining parts, we will be discussing about these various aspects of a legally enforceable valid contract. The very important point regarding this whole law of contract is that if there is a non-performance of contract by any party, other party can take help of a court. However, the court shall intervene only if the contract complies with all the requirements of the law of the Contract Act. So, what are these requirements which make a contract a legally enforceable one? This is what we shall be discussing hereafter in this part and in subsequent parts of our discussion. Before going deeper into various legal aspects of a contract, it would be useful to understand some legal definitions to see how some everyday terms are defined in the law. Contract, agreement, offer, promise. These are the terms which we use in a very common manner. However, these four are the most important terms to understand with reference to the Contract Act. Though we use these terms in a routine manner, but they have been given a very specific meaning in the Contract Act. And there is a definite set of relationship amongst all these four terms. So in next few slides, we will be discussing the real legal meaning of all these four terms. So let's start with the definition of the fundamental concept, contract. What exactly is a contract? How the law defines the term contract? Section 2 clause H gives us a very simple single line definition, that is, an agreement enforceable by law is a contract. So as per law, any agreement which is enforceable by law is a contract. Mathematically, we can put it in this manner: contract is equal to agreement plus enforceability by law. This definition obviously leads us to another question. Then what is an agreement? Let's see in the next slide. If a contract is an agreement enforceable by law, so how we can define an agreement? The law says, section 2 clause E, every promise and every set of promises forming consideration for each other shall be treated as an agreement. So an agreement is basically a promise or a set of promises which are forming consideration for each other, and they will create an agreement. Say for example, A agrees to pay ₹100 to B, and B agrees to give him a book which is priced at ₹100. Now this is a set of promises. A is promising to pay ₹100 to B, and B is promising to give a book to Mr. A. This set of promise which is forming consideration for each other, and that's why this is an agreement. So a contract is an agreement enforceable by law. Agreement is promise or set of promises. This obviously leads us to another question. Then what is a promise? Let's see in the next slide. So contract is an agreement enforceable by law. Agreement is a promise or set of promises forming consideration for each other. So now what is a promise? The law says, when one person signifies to another his willingness to do or not to do anything with a view to obtain consent of that other to such act or such abstinence, this person is said to have made a proposal or an offer. Then, when the person to whom the proposal is made, he accepts this proposal. When he signifies his assent thereto, the proposal is said to be accepted. Section 2 clause B says, a proposal, when it is accepted, becomes a promise. So a promise is basically a proposal made by somebody and accepted by another person. These two parties, one who is making the proposal is called promisor, and other person who is accepting the proposal is called promisee. After contract, agreement and promise, the fourth important terminology is consideration. Now, how the law defines consideration? The law says, when at the desire of promisor, the person who is making an offer, the promisee or any other person has done or abstained from doing, or he does or abstains from doing, or promises to do or to abstain from doing something in future, such an act or abstinence or promise is called a consideration for the promise. So the consideration is a fairly described kind of definition under the Contract Act, and the law says the consideration may be a past consideration, something which has already been done. It may be a present consideration, the promisee may do something in present, or it may be a future consideration, he may promises to do or to abstain from doing something in future. All these are various different forms of consideration. And just to recapture, every promise and every set of promises forming the consideration for each other is an agreement as per section 2 clause E. An agreement enforceable by law is a contract as per section 2 clause H. To summarize the whole idea of contract, let's see it in the form of flow of events. There is a proposal that has been accepted. There is a consideration involved for this proposal. This will make an agreement. If this agreement is legally enforceable, now this will get converted into a contract, or we shall see in later part an agreement which is not legally enforceable. This may be a void or a voidable agreement. This is the complete flow of events so far as a contract is concerned. Thank you.